Hi guys, I hope you all are doing well. This is Saishpreet Kaur and you're watching Legal Bites. In this video, I'll be looking at the legal maxim Assentio Mentium or consensus ad idem. In this video, I'll be covering the meaning and origin of the maxim, the application, a few illustrations, and last but not the least, some important case laws to understand the maxim better. So let's get right into the video. Let's start with the meaning and origin of the maxim. So, Assentio Mentium is a legal term of Latin origin. In Latin, Assentio Mentium literally means meeting of minds or mutual consent. Assentio Mentium is synonymous to consensus ad idem, which is again a legal term of Latin origin. So now that we know the literal meaning of the maxim consensus ad idem or Assentio Mentium, let's understand it from a legal perspective. So this maxim is most commonly used in the contract law, and section 13 of the Indian Contract Act talks about the same. It basically means that all the parties have mutually agreed to the same thing in the same sense. Let's discuss the application of the maxim Assentio Mentium or consensus ad idem. तो जैसे कि हमने पढ़ा, section 13 of the Indian Contract Act says that all the parties are said to consent when they agree to the same thing in the same sense, which is Assentio Mentium or consensus ad idem, meeting of minds. Now, one of the most important prerequisites before entering into a contract is that the consent of all the parties must be free. और consent कब free नहीं होता है? When it is induced by coercion or undue influence or misrepresentation or fraud or mistake. And if the contract is induced by either of these, then the contract is said to be voidable at the option of the aggrieved party. Now let's understand the usage of the maxim Assentio Mentium by looking at this illustration. Okay, so there's A and there's B. A agreed to sell his house and B agreed to buy the same house. B additionally also agreed to a few terms and conditions which A laid down. So now in this case, A and B agreed to the same thing, that is the same house and in the same sense. So there was presence of Assentio Mentium or there was meeting of minds. And hence this is a valid contract. Next up are the case laws. The first case is that of Brij Mohan and others versus Sugra Begum and others. So it was in this case that the court held that even oral contracts of sale can be considered as valid contracts. However, in such contracts, huge burden lies on the plaintiff to prove that there was consensus ad idem or meeting of minds while entering into the contract. The second case is that of Smith versus Hughes. It was in this case that the court held that mere silence does not amount to fraud unless the circumstances of the case imply the same or there existed a special trust or confidence between the parties.